What happens if the owner of a would-be corporation starts running the business before it's officially incorporated? Robertson versus Levy considered whether the owner of a failed business could fall back on common law notions of de facto corporations, or whether he was bound by the requirements of modern business corporation statutes. Martin Robertson and Eugene Levy entered into an agreement under which Levy would form a corporation called Penn Avenue Record Shack, Inc., which would purchase Robertson's business. Levy submitted articles of incorporation to the Superintendent of Corporations on December 27th, but didn't receive a certificate of incorporation at that time. Robertson and Levy entered into an assignment of the lease on December 31st, with Levy named as president of Record Shack. The Superintendent of Corporations rejected the articles of incorporation on January 2nd. Nevertheless, Levy started operating the business that day. On January 8th, Robertson executed a bill of sale of all his assets to the corporation. Levy gave him a note promising installment payments, signed, quote, Penn Ave Record Shack, Inc., by Eugene M. Levy, President, unquote. The certificate of incorporation was issued on January 17th. Levy made one payment on the note. Then he ran out of money. Record Shack ceased doing business in June. Robertson sued Levy for the balance due on the note. Levy argued that because Robertson had accepted a payment from the corporation, he was stopped from denying that a corporation existed, and Levy therefore wasn't personally liable for the corporation's debts. The trial court found for Levy. Robertson appealed to the Court of Appeals for the District of Columbia Circuit, claiming that Levy was liable because he'd acted as a corporation without authority.